Division 1 is now in session.
Thank you all. Please be seated. Good morning. This is the time set for oral argument in our case number CV140005, 4Cs Property Management LLC versus the Bruce and Ann Brown Limited Partnership et al. Each side is allocated 20 minutes for oral argument. The appellant is free to use a portion of that time if you wish to do so. If you wish to do so, you need to keep track of your own time at the podium clock. Out of respect for counsel, I would ask those in attendance to make sure your cell phones are off or in the vibrate position so arguments and presentation are not interrupted. We have read the briefs. We've conferenced the matter. We encourage you, and we did that this morning, we'd encourage you to keep that in mind as you present your oral argument to us today. Our proceedings are being recorded and they will be placed on YouTube in due course. So as you begin your argument, I would ask that you please tell us your name and the party that you represent. With that, we'll hear from appellant Ms. Foster.
Good morning. My name is Teresa Foster, and I represent the appellants, which is a couple parties, 4Cs Property Management and Reed and Marcy Ann Johnson. The central issue here today is the fourth trial judge reconsidering prior rulings from prior trial judges that resulted in conflicting rulings for different parties. And the issue was the effective date of an easement that resulted in the conflicting rulings. The easement was created by a 2005 contract, and there was a judgment reformation in 2008. And the conflicting rulings I'm talking about are Exhibits A through D to the appellant's opening brief. With regards to Murphy, Judge Hauser found that the contract created easement as of the date of 2005. But that ruling, in its Appendix A, goes farther than that. In that ruling, Judge Hauser also denied Brown's cross motion for summary judgment against the plaintiffs. And what that concerned was Brown's counterclaim for quiet title and trespass. And that's part of the record, IRA 15. Well, for Brown not to have his claim for quiet title and trespass was because the easement was effective as of the date of the contract. If it was effective as of the date of the contract, then the appellants did not trespass on Brown's property and they did not cause any interference issues with regards to Brown. That ruling went up on appeal. The memorandum decision is Appendix B, and the Court of Appeals affirmed it. So we have a final judgment here, and a copy of the judgment was attached to Brown's response brief as Appendix 1.
Let me ask you, and
Yes.
that's a judgment, and let me see if I can get a date so we're talking on the same point. Are you talking about the judgment was entered in July of 2008?
Yes, I am, Your
Okay,
Honor.
all right.
Yes, I
And that-
am.
Yep.
And in that judgment, which is attached as Appendix 1, the court states the judgment is entered in favor of plaintiffs and against Brown on Brown's counterclaim for quiet title and trespass. The judge goes on to state that the deed from Murphy to Brown, which was recorded in 2006, shall be reformed. And then language was also added in there about the easement being effective upon the recording of that judgment. Keep in mind, if you look at Exhibit 90, Brown had refused to sign a deed for reformation, and he had refused to sign an easement. And what we had out there was a contract in 2005 that was not recorded that provided an easement for 25 feet in length. We also had a survey that was recorded that did not have easement grant language that had an easement for 30 feet. So under the reformation, the easement was based on the contract 25 feet in the middle of that survey, which was recorded. So that's what Judge Hauser did. Next we have...
So, counsel, before
Yes.
you move on from that judgment, under its plain language, it says the easement shall be effective upon the recording of this judgment. If your clients were not satisfied with that, or were they perfectly satisfied with that language? And if they were not, then they absolutely had the right to cross-appeal, correct? To file a cross-appeal.
This language was proposed to basically satisfy title company requirements. We did not have an easement that was recorded until this judgment.
So you're saying you did not agree with this language about the effective date of the...
We had to agree with it to satisfy title company requirements, Your Honor. The title company wanted something recorded.
Still couldn't file a cross-appeal?
file a cross appeal. This judgment was prepared and agreed to by the
I understand
plaintiffs.
that. I understand it doesn't matter who prepared and agreed to it. You could have cross-appealed from the judgment and challenged that and said, this has to be effective back to the date of the contract, not the date of the judgment.
Well, Your Honor, the same judgment has language in there that says the deed that was recorded on 2006 is reformed to include the easement. It has that language in there
I
also.
understand that, but then it has language saying, quite clearly, to me at least, that the easement shall be effective upon the recording of the judgment. I mean, the word effective, what does that mean? It means it comes into play, it springs to life? I don't know what the word effective means.
Well, it means Brown didn't have to sign a new deed or an easement to have it recorded. The judgment itself was going to reform that deed and have the easement recorded.
Which is fair, but that didn't occur until the 18th of July, 2008, right? Isn't that the date that was recorded?
The judgment, correct.
Yes. No, that's exactly right. And
Yes.
And then there were, for purposes of our appeal today, and I understand your reference to 4, judgments or decisions. Provisionally, I've referred to 3 judgments because you have the original judgment you're talking about, then the judgment dealing with the claims involving the Murphys, and then the judgment that brings us here today.
Correct.
And
McVeigh's did not result in a judgment.
right,
Okay.
right. Summary judgment motion practice, but not a judgment as defined under the rules of civil procedure. But the real issue here, I mean, your argument, I think, has to be somehow that the judgment that brings us here today is inconsistent with the first judgment as well, right?
And more so the second judgment, Your Honor, the
Well, and I
judgment involving Murphy.
I understand the second judgment, and I want to hear more from you about that. But as to the Browns were not parties to that judgment.
The Browns, well, there was 2 motions pending before the court. There was a Browns motion against the plaintiff, which you're right, was denied.
The court found there are issues of fact we got to resolve at trial, and that's what resulted in what I will refer to as Judgment 3, the judgment that brings us here today.
Correct.
But as to the claims involving the Murphys, those were resolved on motion. There was a putative appeal for that was then abandoned.
They resolved on motion based on the effective date of the easement, Your Honor.
Well, and I understand what you're saying, but that's imputing a fair bit to what the text of the judgment says.
Well, if you look at the underlying pleadings, if you look at what Murphy filed his motion and how the court ruled, plaintiff's claims against Murphy, and these are really Exhibits 8 and Exhibit 12. What happened is Exhibit 8 is Murphy's real estate agent gave the plaintiffs a copy of a survey which showed the recorded easement. And then in connection with the closing, Murphy also signed an affidavit of disclosure which said that the legal and physical access were along the same location, which is what that survey was.
Let me ask you, was your client's claims in the Superior Court as to the Murphys and the Browns, were they, because you can plead inconsistently, right?
Absolutely.
Were they inconsistent with each other?
Absolutely.
Okay.
We didn't know initially who was going to be responsible.
All right.
So once we file against Murphy, we say that there's been interference, we've been damaged from 2006 to 2008, and Murphy alleges, wait, Your Honor, the deed's reformed back to 2005. I can't be legally responsible.
Right.
That's where you come in with the inconsistencies.
Well, but that was a final judgment as to the Murphys and as to your clients on that claim, not as to the Browns, because they weren't parties to that. And that's why, at least as I read your briefs, you stop just short of saying there's res judicata or collateral estoppel. Your argument's really law of the case.
Yeah, I never use res judicata or collateral
and that's
estoppel.
fair. I think that's a fair reading of that doctrine. And then we can talk in a bit about some jurisdictional arguments, because law of the case and horizontal appeal is really, I think, typically different than a jurisdictional issue. But you had an opportunity, if you didn't like that judgment as to the Murphys, to keep sort of that claim alive, to appeal. And I don't know if you were on the case at the time, but there was a start down that path. And then the appeal was abandoned or not pressed or however, and it didn't go forward. It was dismissed.
But that judgment was correct, Your Honor. If the deed was reformed to include an easement that was agreed to in 2005, then Murphy wasn't responsible for negligent misrepresentation, because that reformation of the deed, which relates back to the deed, Murphy's representations became accurate. There was legal and physical access along the same location, which was along that easement, because the 2006 deed was reformed by the 2008 judgment to include that easement. So Murphy's representations became accurate because of that reformed deed.
Vis-a-vis the Murphys, and that leaves the claims that we're addressing here and arising out of Judgment 3. So your argument is, as I gather from the briefs, and this is a unique case. This
Very unusual.
It doesn't really fit in any well-known, well-traveled bucket or path in terms of procedure. But your argument, as I hear it, is that the fifth judge, the judge who presided over the bench trial, lacked the ability to make the determination that she did on the date of the effectiveness of the easement, either given prior rulings by the court or given the discretion she had in making that call, given that it really is an equitable call that she was making, or otherwise. Isn't that kind of the core of what your argument is?
Yes.
And I've been interrupting you a fair bit, and I appreciate your patience with that, but let me
I
hear.
want to answer your questions.
Well, and I appreciate that too, but let me hear more about why that court, under law of the case and horizontal appeals concepts, recognizing she had now a full trial record, looked at witnesses in the eye, received nearly 100 exhibits, if I read the record right, and heard additional argument, why that court could not make that decision on the effective date as to your client's claims with respect to the Browns.
Okay. Well, if you go back to Exhibit B, which was Budoff's decision, in his decision, remember, Brown tried to have the claims that the plaintiffs made against him for interference dismissed because he says, I never interfered after the 2008 judgment, and the deed was effective on the 2008 judgment. And again, that was not a final order, but the court decided these two cases together with regards to Brown's motion and Murphy's motion, and says the court determines that plaintiff's right to use the easement was created by contract and not dependent solely on the date of reformation. Plaintiff had a right to rely on the existence of the easement based on the contract between Brown and Murphy. Well, if we're relying on the contract, we're relying on a contract that existed back in 2005.
And if that went to judgment as to the Browns, I think you have a lot stronger case, but it didn't. That was a sort of inchoate order based on motion practice where the court found, as to your client's claims against the Brown, there are issues of fact.
You're talking about the fourth judge, the trial judge.
Well, the issue that ended up in the second judgment where the putative appeal was taken,
Okay.
that denied, didn't it, finding issues of fact, summary judgment with respect to the Browns issues?
Yeah, they had raised two claims. One, they did not interfere before 2008, and they thought that was the effective date. And two was that they said that there weren't any damages after that date.
And the court said, can't decide that as a matter of law. That's got to wait trial.
Correct, correct.
And that's what happened.
Correct. But keep in mind, and I haven't gotten to McVeigh's yet, the reason why I'm talking about the conflicting decision, under Judge Hauser's claim, and this is to Brown's, this is really to our benefit, the court threw out Brown's claims against my client for interference because the easement was effective as of 2005. So we couldn't interfere. Now, that is a final judgment that involved Brown. We could interfere.
But Brown wasn't a party to that.
No, yes, he was. I'm talking about the Hauser judgment, the first one.
The first one is the one that Judge Brown had asked you about, saying, wait a minute, doesn't the judgment say it's effective upon recordation?
And that's the same judgment. That's why I said you have to look at the judgment as a whole. There's two more parts to that judgment. Now, this Hauser's judgment, this is Appendix 1 to the
And just
Brown's
to clarify, it's the judgment that was entered in July of 2008.
Correct.
Okay.
Yes, yes. And that judgment says two more things. One, that the deed from 2006 shall be reformed to include an easement, which was reforming a deed that existed as of 2006. That relates back to the 2006 date because it's a reformation. This judgment also had a final judgment language against Brown's, which says judgment is hereby entered in favor of plaintiffs and against Brown on Brown's counterclaim for quiet title and trespass. And the reason that those were thrown out was because we could not have trespassed if there was a valid easement back in 2005.
But
if the easement did not exist.
Doesn't that get back to, though, I thought the appeal that the flavor of your brief is, it seems to me, that the third judgment, the judgment that we're here on appeal for, is inconsistent not so much with the first judgment, but with the second judgment, where your client, where the Browns were not parties.
It's actually inconsistent with the two judgments, Hauser's and Budolf's, and the ruling from McVeigh that did involve Brown.
And
Inconsistent with all of them.
McVeigh, well, tell me how it's inconsistent with that first judgment, particularly given the language that Judge Brown quoted.
Okay, and if you look at the judgment, again, this is Appendix 1, the judgment says that the deed from 2006 is reformed to include the easement, and reformation to include the easement relates back to the 2006 deed.
What does the effective date language do then? Why would the judge include that, and why didn't you challenge that?
As I mentioned, had nothing to do with the judge, Your Honor, was to satisfy a title company. Had nothing to do with the judge.
But it's lingering here. I mean, by the very fact that we're here. And in any event, it's there. It is included in the judgment.
You mean the parties didn't even brief that? That came out of nowhere?
No, Your Honor, that came after Exhibit 90, where we asked Brown to sign a reformation deed or an easement, and he refused. And it's not part of the record, but the title company wanted language saying that we didn't need a deed or we didn't need an easement, that this judgment was going to satisfy it, and that's why that language was there, but that's not part of the record. It had nothing to do with the briefing, had nothing to do with the judge. It was purely for a collateral reason. But this judgment also, when you read it as a whole, and this is where I go back to the conflicting rulings, judgment was entered in favor of plaintiff on Brown's claim for interference. It was a matter of law. The briefing showed plaintiffs could not interfere with Brown's property rights if there had been an easement effective as of 2005, because the plaintiffs had a right to use that property. This was a purely legal issue. If plaintiffs did not have a right to use the property until 2008, then those claims that Brown had against the plaintiffs never should have been dismissed. They were dismissed because the interference was improper, because the interference was proper because my clients had an easement based on the reform deed back to 2006, which was prior to the date my clients purchased the property. Does that answer your question?
I appreciate what you're saying, counsel.
I don't mean to beat a dead horse.
No. And like I said, this is one that I don't think any of the three of us, and probably the two of you, have dealt with the case.
And I'm sure we will never have this issue again. With regards to Exhibit D, and this is McVeigh's, and I just want to briefly touch upon it. I realize it's not a final ruling,
right.
But again, Budolf looked at what Hauser did, and McVeigh looked at what Budolf and Hauser did. And Brown's had a claim against First American, and even though they were negligent, Judge McVeigh came out and said that that didn't cause the Browns any damages, and he says that any breach of their duty did not cause damages. This is made clear by the Arizona Court of Appeals. Again, that's because the easement was effective as of 2005, had nothing to do with the title company.
But the Arizona Court of Appeals in the first appeal didn't say that. They didn't say the easement was effective 2005, did they?
No, they affirmed the reformation of the deed.
Right.
And by reformation under general rules of law, and I know this issue wasn't brief because I didn't think it was an issue, reformation relates back to the date of the deed.
And I understand that. And if that was all we had, and the language that we've talked about a fair bit in that first judgment didn't exist, and if Commissioner French didn't have some discretion in determining the effective date under equity, it would be a very different case. But we have all those things, and that's why I struggle with this.
And I'd like to respond to that, but I want to save a couple minutes
And I
for
appreciate
reply.
that.
And just briefly on the attorney's fees issue, I would like to refer you to that Bar J. Bar case, and that was an interference with contract. It says that, a contract may exist, but there's no interference is a legal duty, and it's the same thing with regards to an easement. An easement is a property right, and the interference with an easement is more like a trespass or a nuisance. It's a duty that exists without a contract. And I'm going to save my little bit left for my rebuttal.
Thank you, counsel. Mr. Hargrove.
Thank you. May it please the court, Roger Hargrove representing the Applees, Bruce and Ann Brown, and the Brown Limited Partnership. As the court has noted, this case has had a long history. It's been before numerous trial judges and one trip out to this court. And I will assume that the court is well aware of the vigorous litigation that went on before the first appeal, with Brown's basically taking the position that while they never denied that the contract that they signed provided the right to Murphy to reserve an easement or to dedicate a public roadway through the property being sold by the Browns. In fact, nobody did anything about it during the escrow period. It was not Brown's responsibility to document an easement across their property. It was Murphy's responsibility to provide an easement during escrow as provided in the contract, and for the title company to properly document the transaction if an easement was to be part of it. But I won't dwell on that because there was two years of heavy litigation and Brown's arguments about merger into the deed and waiver by Murphy by closing without any recorded easement or without any dedication of a public roadway or without any reservation of an easement in the deed. I mean, that's undisputed that was the situation when Browns acquired title to this property, and when plaintiffs purchased the adjoining property 9 months later and the claims of an easement came up, first thing Browns did before they resisted plaintiffs' claims was to check with First American and see if there was an easement across their property, and they were told there wasn't. And that brief background and part of the evidence at the trial was important because this only involves, of the numerous claims that have been decided in this overall lawsuit so far, a specific claim against Browns for the intentional tort of interference with an easement. But I was happy to hear Ms. Foster say that the primary issue, the central issue, is the effective date of the easement. And yet we hear her in oral argument today arguing that the effective date of the easement is 3 years prior to the effective date of the easement as set forth in the judgment for deed reformation, which is the July 2008 judgment.
Well, let me ask you about that. It is hard, isn't it, to square the judgment I've called the second judgment. I understand my shorthands may be different than yours, the February 2011 judgment. It is hard to square what you just said with that judgment, isn't it?
And by the second judgment, Your Honor, I assuming you're referring to the judgment on favor of Murphy on plaintiff's claims against Murphy.
Right, which I think, and I'm trying to use dates because we're using different appendices and different, as shorthands, but I think it was entered February 2011. But I think we're talking about the same.
That's correct, Your Honor. There were a lot of issues briefed by all parties in connection with the motions for summary judgment that were heard by Judge Budoff. I don't know how Ms. Foster knows the judge's thinking on what arguments were accepted and what arguments were not. To our way of thinking, Murphy's arguments were directly against the law of the case as established by the July 2008 judgment. But the judgment itself gives us no clue about what the judge is thinking.
Well, but what you just described doesn't it? If the Murphys were arguing in a way that I think you just described from your impression as inconsistent with Judgment 1, the July 2008 judgment, and they get to go home, right? I mean, they're dismissed out of the case at that point.
Yes.
That's where it's hard to square those.
Their catch-all argument was, no matter what, the plaintiffs, 4Cs, bought a piece of property that had no recorded easement across the Browns' property. According to the evidence at trial, and it's in the brief, their title company would not even ensure that easement survey that was recorded provided any rights whatsoever. Plaintiffs went ahead and purchased the property, notwithstanding the fact that there was no right of access that they claim as of record. And the final argument by Murphy was, I can't be liable for negligent misrepresentation because there was no right to rely. There's nothing of record that gives 4Cs the right to the access that they claim they need to develop the property. And that's an important point, too, that...
Does the law require that? For a negligent misrepresentation claim, does the law require that something be of record before reliance can be reasonable as a matter of law?
I don't know the direct answer to that, but certainly there has to be a right to rely on the alleged misrepresentations of Murphy that there was access. And
So so I thought the Murphys signed a document that said that there is access to this property. Didn't the plaintiffs have a right to rely on that?
That was exactly what I was getting to, Your Honor. What the Murphys represented was that the legal access and the physical access were one and the same. What they represented did not represent specifically that there was access across Brown's property. There is, in fact, legal access and physical access from the southern portion, the opposite direction from Merriam's Way. Now, Ms. Foster has always had arguments, well, that's true. There is legal and physical access there, but it's too expensive to build a road to develop the property. Well, that was their decision on what they were going to do with the property, whether they're going to use it to go pitch a tent on or hike on, or whether they were going to subdivide and develop it and put a bunch of roads through it.
So you're suggesting that's why the Murphys were able to be dismissed from the case then?
I think that's a more logical explanation than that Judge Budoff was saying, I don't buy what the final judgment says that was affirmed by this appeal, that the effective date of the easement was something other than what that judgment says.
Well, but couldn't you read the minute entry to say it's not that he doesn't buy it, it's just that he takes a somewhat more nuanced approach as to what the judgment meant?
I wish I could explain why that comment was necessary, Your Honor. I don't disagree that the origins of the right to an easement are created by the contract. I mean, if there wasn't the Brown-Murphy contract, there wouldn't be any, and this goes to the attorney's fees issue later on, there wouldn't be any easement. But the conceded point that the interference claim depends upon the effective date of the easement. In other words, there has to be an enforceable property right by plaintiffs in order to pursue an intentional tort claim for interference with the easement. They didn't have an enforceable right until they got what they asked for, was a judgment that says they have an enforceable right. And that's the July 2008 judgment that couldn't say any clearer that the effective date of this easement is when it is recorded, and it is undisputed that there was no actionable interference with the easement after the recording of that judgment in 2008.
You've heard your counterpart talk about why the effective date language originated in the judgment. Do you recall briefing or discussion of that?
I have to confess, Your Honor, that I was not involved in the trial court. Browns were being represented through the title company at that point, and I got involved for purposes of the first appeal. I do note that judgment bears the letterhead in the upper left-hand corner of plaintiff's counsel. I mean, certainly Browns didn't propose that judgment. If they were dissatisfied, there wasn't any appeal from that. But, in a larger context, I mean, the law is quite clear that reformation as between the parties to the deed would relate back. But that's not the same thing as saying that third parties who are not parties to that deed then get a retroactive interference tort claim because Browns acted in accordance with the deed. And we do cite some authority for that proposition. And
let me ask if Judge French at the bench trial, and she made some comments before the bench trial, maybe at the beginning of the bench trial, indicating she was inclined to look back to 0506. Now, ultimately, she didn't do that. But did she have the discretion to make that call, whether the effective ability to use the easement and the interference with that easement either should be retroactive or should apply as of July 18, 2008?
I would say absolutely not, Your Honor, because of the law of the case as set forth in the July 2008 judgment. It expressly says when that easement is going to be effective. That effective date language was quoted in this court's opinion, and that entire judgment was affirmed on appeal. And my viewpoint is that plaintiffs 4Cs are attempting to do in this appeal the same thing they did in the trial court, which is basically ignore and avoid the effective date of the easement language in the July 2008 judgment. You'll notice that that very important document is not included in their appendix. The effective date language is only referenced one time in their entire opening brief and reply brief, and that's when they're quoting portions of the pretrial statement. There's no discussion any place in the record or in the briefs about what that language means, if it is as they contend that it means something other than what it clearly states. But in the plaintiff's trial memorandum that was submitted the day before trial began, it likewise contains no reference to the judgment for deed reformation language about the effective date, and states in the introduction, prior rulings have confirmed both the existence of the easement, which Browns, of course, did not dispute at that point, and the effective date of the easement, the date of the contract between Brown and Murphy. Judge French accepted the argument, but by the time everything was presented in a logical sequence with nothing left out, she arrived at what I think is a correct conclusion, that she basically had no jurisdiction to do anything other than honor the law of the case as set forth in the July 2008 judgment. And under the law of the case, I don't think we really have any dispute about it. It's clear the appellate court's decisions are binding on the trial court in subsequent proceedings in the same court, and a superior court judge has no jurisdiction to review or change a final judgment of another judge. And so, that's, again, my answer to your question is she had no jurisdiction to do otherwise, and she correctly applied the law of the case.
Let me ask just a point of clarification. Your clients and appellants take property interest from a common grantor, the Murphys.
Correct.
Using that term sort of generically. But the parties before the court today do not have any contractual relationship with each other. Is that fair? There's no contract between 4Cs and the Browns that's relevant to this appeal?
There is no contractual relationship between the parties to this appeal, but I guess that logically leads me to the issue of attorney's fees.
Okay, go back to that for a second. I follow up on that. What do you mean there's no contract? There is an easement across the Browns' property, and it burdens their land. It was talking about benefits and burdens. It burdens the northern parcel for the benefit of the southern parcel. Isn't that a contractual relationship between the parties?
It's there.
I mean, if I have an easement across your land and I drive over it every day, don't we have a contract that you're going? Or I mean, I don't know if you call it a contract. Maybe that's the wrong terminology. But the law, property law, says I have the right to drive across your property each and every day, or how many times a day, and then you agree to allow me to do that. That's our agreement. That's the agreement. Maybe not a contract. That's the agreement we have, isn't it?
Well, that's your property interest, I would think, Your Honor. But as far as there being a contractual agreement executed by the Browns and 4Cs, there was nothing, and nor was there an express grant of easement that would be maybe could be construed as a contract between the Browns and Murphy, because it was never documented.
But doesn't that position hurt you on the attorney's fees?
Well,
request.
Not the way we look at it, because the attorney's fees issue comes up primarily because of the way Four Cs tried this case, they urged that their rights to the easement and their rights to prevent interference with it originated from the Brown-Murphy contract in September of 2005, which was 6 months before anybody knew anything about plaintiffs, before they'd ever come on the scene. But they tried the case by refusing to acknowledge the effective date of the easement as set forth in the judgment for deed reformation, and insisted that the Brown-Murphy contract gave them rights to enforce the easement from the date of that contract. So Four Cs was asserting a contract right as a basis for the interference claim, completely independent of the judgment for deed reformation. And that's why this claim that was ultimately unsuccessful arises out of the contract, as of a contract for purposes of 12-340-101.
But that claim and the appeal involving attorney's fees is either there's a right under 12-340-101 for fees on a tortious interference with easement claim, or there's not. That's the issue we're asked to decide. And the claim that you described, the tortious interference with easement, doesn't require the breach of a contract, right? In fact, it doesn't require a contract at all. An easement can have a variety of different sources. Would you agree with that?
I'm trying to think about what the variety of different sources would be.
Prescriptive easement, prescriptive.
Public,
Sure.
Public easement, implied
public
easement.
dedication, sure.
Okay, but I'm talking about the specific allegations of this case.
Sure,
and plaintiffs claim their rights through the Brown-Murphy contract. They're saying that's what gives us the right to sue you for all of these lost profits we supposedly had prior to 2008.
But isn't the duty to not interfere with an easement, regardless of the easement source, that's a duty imposed by law, not by contract, right? In other words, if I have a right to use an easement, whether it be by dedication, prescription, contract, take your pick, it is the law of the state of Arizona that says if you, for example, interfere with that right, I have a tort claim. That doesn't involve you breaching a contract.
And
It's
Your
an
Honor,
independent obligation.
Your point would be 100% right if Four Cs had only sought interference damages after the date of the July 2008 judgment, which says when the effective date is. They said, no, we don't care about that as the source of our property right. We are claiming a property right through and only because of the Brown-Murphy contract.
But I hear their argument, at least today and in the papers, is a little more nuanced than that the reformation typically is retroactive. And if it was retroactive but tied under the judgment, would your argument still hold serve?
With the general rule being that the reformation being retroactive between the parties to the deed in this case, it's not retroactive for all purposes. It's not retroactive for purposes of this.
I understand that legal position, but let me ask you to get beyond that in the hypothetical or perhaps in what happened here. If the claim for tortious interference of easement was based on the July 2008 judgment and the thought that it was retroactive as to the two parties, the two sides in front of us today, doesn't that still originate from a duty apart from the contract, originates from the judgment obligation by law?
Your Honor, I'm still not getting there. I don't think that they had any enforceable right until the effective date of that easement. I mean, it doesn't give them any rights retroactively now.
And I understand.
Now, maybe there's some language that would be interpreted differently if we're talking about Murphy, but where we clearly get to here is, but for the Brown-Murphy contract, where would plaintiffs get a right to claim that we're interfering with an easement? for something that happened prior to 2008. There is absolutely no basis but the contract, and so that's why we meet the but-for test, and that the trial court properly alleviated some of the burden that the Browns have been through over these years by awarding contract damages.
And counsel, I appreciate your argument. Your time has expired.
Thank you, Your Honor.
Ms. Hargrove, rebuttal. Or, I'm sorry, I misspoke. Ms. Foster.
Not a
I have
problem.
to flip the signature blocks here. I apologize.
Not a problem. You know, you asked about Murphy getting to go home, and I want to address that. In Judge Budolph's minute entry, he stated, "The court finds there is no reasonable interpretation of the actions of Murphy that could be construed as negligent misrepresentations to the plaintiff." Mr. Hargrove said that we don't know what was in the judge's mind, but we know what was presented to the judge. And what was presented was Exhibit 8 and Exhibit 12, and the plaintiffs had the right to rely on the direct representations of Murphy. Exhibit 8 was a survey showing the easement recorded against Brown's property, and Exhibit 12 was the sworn affidavit of Dr. Murphy stating that that legal and physical access was the same. And this was also supported by testimony of Pam Stevenson at page 127 to 132. And besides the exhibits and the testimony, we also have what was presented to Judge Budolph. And what that was Murphy's motion for summary judgment and his reply. And I quoted the relevant provisions on that in our reply brief here. And it's on page 6. What Murphy told Judge Budolph: "The court has entered summary judgment establishing that when the property was sold, an easement across the Browns' property existed for access to the plaintiff's property. The easement at all times existed but for the unwarranted conduct and legal protestations of Browns. Understandably, if there was no such easement and the plaintiffs had purchased the property believing in the existence of such an easement, then the plaintiffs may be in a different position." And Murphy's attorney stated in his reply, "The fact that the deed has been reformed to meet the Murphy-bound contract's intent ratifies and affirms the truthfulness of Murphy's allegedly false and negligent misrepresentation." And again, that's relating to Exhibit 8 and Exhibit 12. If you go from there and look at the trial judge, Judge French's minute entry, she recognizes, and this is Appendix Exhibit F to plaintiff's appellant's brief, and this is the March 20th, 2013 minute entry. She states, "The general rule is that an easement would be effective upon recording of the judgment." I'm sorry. The general rule is that the easement would be effective relates back to the date of the original instrument. And then she goes on to state that while a reformation cannot negatively affect the rights of an innocent third party such as the plaintiffs cite no authority for the proposition that as third parties to the original entrance, they are entitled to receive the benefit of the reformed instrument. We didn't find any law to that effect, but the law generally is that the reformed deed relates back to the date of the deed. The appellee...
As to all parties, no, regardless of where they're parties to the contract. As to the whole world, it relates back?
It's interesting. If you look at the case that the defendant cited in their or the Brown cited in the response brief, and I think it's Mellicone, regarding reformation, in that case, the court acknowledged that reformation relates back generally, and it's even binding on intervening creditors. I mean, if it's binding on intervening creditors, that's to their detriment. In this situation, the judge stated that rights of an innocent third party, well, plaintiffs were an innocent third party. Plaintiffs are basing this easement right based on the contract between Murphy and Brown, which the prior judges have agreed that the plaintiffs had the right to rely on those representations, and we are an innocent third party. We relied on those representations, and Judge Budolph comes out and say, you can't go after Murphy for my time's up, after misrepresentations.
Counsel, thank you.
Okay, thank you.
Thank you both. As I indicated, we have not seen a case like this before. You've given us much to think about in your written briefs and as well as during oral argument today, and we appreciate that. We will take the matter under advisement. We'll issue a ruling, written ruling in due course. Now we're going to take a brief recess while we set up the courtroom for our next oral argument.